Good morning, ladies and gentlemen, and thank you for coming to the 9th Annual Public Interest Environmental Law UK Conference. My name is Josceline Cluff, and this is my co-chair, Ali Nihat.
Just to begin with some prosaic detail, we have some health and safety and some directions to go through. For all of you wishing to tweet during sessions, obviously keeping your attention on the speakers, I can give you the Wi-Fi code. It might make sense to give it out while we're all in the forum. The account is CityGuest, for those of you looking to log on, and the password, if anyone has a pen, I would ready that right now. I can give that to you. It's lowercase, all lowercase letters, GTARBF9V. As I said, we hope you will tweet on some of the developments during the day. Some of the important questions. First, toilets. I think you will have noticed upon coming down the stairs on your left, those will be the nearest restrooms. So please note that. If you have any questions or any queries, please do speak to reception or as your first port of call to members of the committee. We're designated by our badges and our black suits. In addition, there's a no smoking policy, and I'll run through what happens in case of fire, which shouldn't be a problem today. First of all, it's important that if you do witness a fire, if there is a sustained fire alarm, you don't take all the time in the world to gather your belongings. We just go to the muster point. Fire alarm sounders are located in all parts of the building. On hearing a continuous fire alarm, leave the buildings by the nearest fire exit or as advised by the fire wardens, who will be wearing either yellow or orange high-vis jackets. Exits can be located by following the green signage located around the building. All exits are visible by a lit sign and will open automatically on activation of the fire alarm. Don't use lifts in the case of fire or re-enter the building unless advised by the wardens to do so. Ladies and gentlemen, please do wear your badges at all times so that you can be allowed in and out of the building. I think that's all we need to go through in terms of health and safety. It remains for me to just quickly say a few words about Peel. So as many of you will know, Peel UK is an entirely student-run, not-for-profit organisation. This is our 9th annual conference. We are run by students from around the University of London who want to draw the attention of the public, of students, and of academics and other NGOs and interests to a pressing topic in environmental law. Today's topic is satisfying consumption, trade in the environment, and we're very pleased to celebrate our 9th year. We are sitting in this rather handsome conference room that's been provided to us very kindly by Cass Business School, so we say thanks to them. Cass Business School is affiliated with City University, who are one of our official partners and have been a great help to us, so we say thank you to them. Our other official partners who have provided great assistance, be it financially or in terms of materials and expertise, are UCL, Queen Mary's University, and Environmental Jobs, so we thank them. A great thank you in advance to our speakers, who are the lifeblood, or we should say the lungs of the event. They give their time freely, and it's really testament to their great passion for the issues discussed today. And we're very proud to have 16 speakers from a very, very wide range of backgrounds and perspectives today. I will say that we have stalls outside from a variety of organizations. There will be the Gaia Foundation, Client Earth, Women for Conservation, UKLA, Friends of the Earth, Holistic Law, and some leaflets on A-Law. So please do avail yourself of the opportunity during break times to find out what they're doing and to hear from them.
We'd like to say a very special thank you to our wonderful chair, Professor William Howarth. William Howarth is Professor of Environmental Law at Kent Law School and co-convener of the LLM programs in Environmental Law and Policy and International Environmental Law. Among other editorial work, he is editor of the Journal of Water Law and a member of the editorial board for the Journal of Environmental Law and Environmental Law and Management. He is an active member of the International Association for Water Law, the United Kingdom Environmental Law Association, the Agricultural Law Association, and the Institution of Fisheries Management. We appreciate his great expertise and continued support of Peel. Thank you very much.
I'm extremely grateful, Ali, Josceline, for the very kind introduction you've given, and you've given me in particular, but I think it's the other way around. I'm pleased, indeed privileged, to be asked to come here again to chair this conference. I'm really looking forward to the day's proceedings. Last year was great, and I'm sure this year will be at least equally good, and an early start, not just you, but the whole of your organising team, for all the efforts that have gone into what looks to be a very interesting conference with some very well-informed speakers from which I, as one, am going to learn something, because there are some issues here which are completely new to me. And I think we're actually starting with one of them. We have a panel discussion on TTIP, Transatlantic Trade and Investment Partnership. And maybe it's not just me, this thing has been kept under wraps for far too long, and there are concerns about the lack of information and transparency on exactly what has been going on our behalf, but it's patently clear that it involves massive issues in relation to the potential conflicts between trade and the environment. I mean, the idea of these things hitting each other headlong is not new. We've seen it at the World Trade level, we've seen it at the European level, and we'll be coming back to those issues. But a transatlantic trade deal, dear, you pause to catch breath of the implications. But rest assured, we've got three excellent speakers to give us a balanced view of the issues. We've got 70 minutes, and as a bad chairman, I'm already a little bit behind time. Allowing the three speakers a maximum of 20 minutes, ideally 15 minutes each, to put forward their perspectives, giving some time at the end for questions. So first off, I'm extremely pleased to welcome Sam Lowe, who is a lead campaigner and spokesman on trade issues for Friends of the Earth. He's been using his skills to convince the House of Commons Environmental Audit Committee of the concerns raised by this, and I'm sure he'll be equally convincing today. So can I first ask Sam to give his presentation?
Hello. Hopefully you can hear me. I always have this problem with these ones because I'm slightly too tall, but I'll lean down a bit. But yes, so thank you very much for having me here. It's a privilege to be invited. I must be very upfront because recently I keep getting introduced as a lawyer. I am not a lawyer. I never have been, but I think that in this world of trade, everyone just assumes you are. So yeah, I'm not, but hopefully you'll listen to me nonetheless, and I can convince you that this is a problem for the environment, which I certainly think it is. To introduce Friends of the Earth, we are the largest grassroots environmental network in the world. We're in about 70 countries. We have hundreds of local groups here in the UK. We're sort of grassroots up into the international sphere. And to be very upfront on our position, we oppose TTIP. I'm just putting that out there now so that it doesn't come as a shock later. And the reason for that, I suppose, I'm going to go through, but we have a sort of vision of the world. We've identified what some of the problems are. We think that the climate is, not going in the right, is not great. We feel that the natural world is being destroyed. And when we look at TTIP, we see something that poses a threat to any action to rectify that. And we also feel that it is not something that will address these problems. So therefore, our interest was piqued. We looked into it, and we started off not fully opposed, and then after not really getting anywhere with the European Commission, which if any of you have dealt with, you won't be surprised by, our position shifted to full opposition, and now they've started to listen to us a bit more. They seem to be more attentive when you blow up a 13-metre Trojan horse outside their front door. So, I'm going to start actually... Oh, have I just destroyed... I'm very sorry. So I'm going to start with actually looking at the benefits, because this is a trade deal. So the idea is that it will reduce prices for consumers. That's effectively what you get from trade deals. So the sort of figures that get thrown around is that it will bring 10 billion a year to the UK economy from 2027. Now, I'm also not an economist, but when I hear economists say that they can predict what's going to happen next year, I'm suspicious. So I'm actually even more suspicious when they say 10 billion a year by 2027. I've not met one yet who's very good at forecasting, and I'm very, very doubtful the people who did this study are. And agreeing with me, so the House of Commons Select Committee, they looked at this and they told the government to stop using these figures because they're nonsense. The House of Lords told them that earlier last year. They still use it, of course, but so that's what's out there. So actually, I mean, to be honest, this will benefit some people. I actually think there's a certain category of the legal profession that could do very well out of TTIP. And some businesses will benefit, but benefit to business does not automatically equal benefit to the economy. And let's be clear, this isn't your classic free trade agreement. A classic free trade agreement would look at tariffs. 80% of the benefits, so tariffs are punitive taxes on imports from other countries designed to protect industry, local industry. 80% of the benefits of this are deemed to come from non-tariff barriers, which is a sort of technical word, but it effectively means differences in standards. So that could be, which I'm sure you will hear a lot from the colleague at British American businesses about how it would be good for cars. So you might be differences in seat belts. Or it could be differences in how you regulate chemicals. It could be differences in how you regulate air quality. You know, it can really branch out. It's a wide field. So 80% of the benefits from there. Pascal Lamy, the former director of the World Trade Organization, described TTIP as a very different beast. So whilst it's clear, it could help some parts of the economy a little bit. When you start playing with regulations, things start to get messy. Because let's be clear, regulations have an economic benefit, despite the fact our trade negotiators don't really like to see it that way. A cost to business is not the same as cost to the economy. If you mess around with chemical, for example, regulations, down the line you can have some serious health impacts. And that costs, and none of this is ever taken into account when they do their studies of the benefits. So there's also other costs. So I'm just going to give a quick example. With the current Canadian EU trade agreement, it's called CETA, which makes everyone think it stands for that. It's actually Comprehensive Economic Trade Agreement, not Canada-EU, because for some reason, I'm not sure why. The EU managed to get the Canadians to extend their patent life on medicines by 2 years. That's going to cost the consumer in Canada close to $1 billion a year. Is that really reducing protections, reducing costs for consumers, or is it increasing costs for people? I remain unconvinced. So at its most ambitious, what you get is a small reduction in prices. Will this make businesses, governments, and consumers start spending loads again? I mean, we've got deflation in Europe pretty much. I remain unconvinced. However, I'm sure you might hear otherwise in a second. But wait, let's get to the environment, what I'm actually here to talk about. Will TTIP affect the environment? If it goes through as envisioned, yes. And I can say that very confidently before getting into the minutiae, because one of the European Commission's main objectives for this deal is to import more oil and gas from the US. I mean, that clearly has an environmental impact. So their own study said it would lead to a small increase in greenhouse gas emissions, which I'm not too convinced by this study. The actual sustainable impact assessment was due last year, but they pushed it back to the end of next year. I've got my suspicions as to why, but I'll leave you to be the judge of that. This is expensive and it's long term. I think the point here is to say to bring over this gas and oil from the US would require huge infrastructure investment to actually create it. There is no infrastructure in place to bring over gas, which I might add is shale gas from the US as of now. That would lead to decades of investment in infrastructure at a time when we're meant to be weaning ourselves off fossil fuels. Why would we be putting in an agreement that would lead to the creation of infrastructure that would lock us into that for the next 10, 20, 30 years? So we have an issue there. I'm going to go on to standards now. So I'm just going to provide some context. As far as the EU goes, I would argue that it has historically been quite good for the UK environment. I think it's led to better air quality, better water quality, amongst other things. However, in the context post-crisis, everything's changed. They've kind of been backed into a corner where the governments can't spend anything. Growth is stagnant or very small, there's deflation. The UK government are threatening to leave unless there's regulations cut. And I would say with the new Commission, we have had a different approach. Since being in, they came in at the end, towards the end of last year, they've already managed to scrap the circular economy, or at least shelf it, which was a waste management type package. They've managed to, under pressure from the Canadians and US under this trade agreement already, they've reduced the strength of the fuel quality directive so as to allow tar sands into the US as part of fuels imported via the US, from Canada via the US. And they're also saying lots of things that concern us. So when they say trust us, TTIP will not reduce environmental standards, I say why should we? You've done nothing so far to prove that I should trust you, why should we now? And let's be clear, this is a trade negotiation. So far, everything that campaigners has taken to the European Commission, for example, there was fears amongst that we'd be importing chlorinated chicken, so chicken bathed in acid after it's been killed, from the US. There was clear fears about hormone-treated beef from the US. The European Commission constantly comes back and says, no, we won't allow that. That's a red line. So far, they've redlined nearly everything the US have asked for. And when it comes down to it, they are going to have to make compromises. That's what negotiations are. And we're very worried that the compromises will be in the fields and areas that are actually quite dear to us. I'm going to talk on a bit more technical level now. So actually, when you look at thanks to the work of campaigners and then MPs and MEPs who now take the credit for it, the European Commission has become a bit more transparent in how they go about this. They have released their proposed texts. It's not the combined text. We don't really get to see what the US say. We sort of find out about that via sources every now and then, but we don't get to see that. So we get to see, and we see that especially when it comes to food safety, the European Commission are proposing a system of mutual recognition. Now, mutual recognition is an interesting one. It's where they've realised that we can't harmonise standards. One way to remove non-tariff barriers, as they call them, is to harmonise it, so we just have the same standards over each. They've realised the actual systems are completely different in the US and EU. We could have told them that, but they've come round to realise it. And so mutual recognition would accept that their system results in the same outcome as ours. Therefore, we can accept food products that are made there and bring them over to the EU without any sort of retesting, because they've gone about it differently, but it's the same. However, we have a concern here, because especially when it comes to food, and however much they say food's not on the table, they have a sanitary and phytosanitary chapter, which means food safety. It very much is on the table. We're very concerned that in the certain areas where the standards do not produce equivalent outcomes, we will be importing products that we wouldn't think are safe. And also, if those products are cheaper to create out there because the regulations are not as strict, they actually will then outcompete our products here, putting further pressure on regulators here and governments here to reduce the standards in the EU. This is also meant to be a living agreement, so going forward they're talking about something called a Regulatory Cooperation Council, which sounds again very tame, and who doesn't like cooperating? But when you actually look at the texts, you see that it would allow business and the US to look at proposed laws and comment on them in regards to their impact on trade before they go to government, before they go to MPs. And we're just quite worried that effectively this institutionalises a lot of the lobbying that happens already. They say that it will be open to NGOs as well to comment, but in reality, the people with the most money do have the most influence, because they can afford to go to all these meetings and they can afford to make their voice heard. To sort of summarise on this section, I say we're quite worried. We're not actually blaming the US too much here. They have their different ways of going about things. We have Friends of the Earth US who are campaigning about it on their side. We actually feel that the European Commission will use TTIP and pressure from mutual recognition to further legitimise weakening and scrapping regulations and standards they don't like, and they will use TTIP going forward as another reason not to raise and strengthen protections in the future. And their reason for doing this is the same as always: growth, jobs, prosperity, but it's done through a very narrow framework that we don't think actually delivers those things and produces risk. I've got 5 minutes left. I'm going to briefly talk about ISDS, which is the Investor State Dispute Settlement side of it, which is why I think maybe a lot of you are interested in this, actually, because it's the more legal side. So these are cases which these are tribunals which allow multinational companies to sue government for public policy decisions in tribunals which are held outside of national law. There's 3 representatives on it. It's usually one representing the company, one representing the government, and one in the middle. And they're usually quite secretive, and they decide, and they're very, very expensive. The average cost is about $4 million per case. And these cases can lead to reversals in environmental policy. So they already exist in some trade agreements. This will be the first time it exists between the EU and US. So Vattenfall is a Swedish energy company. They sued the province of Hamburg in 2009 for $1.9 billion because they were building a coal-fired power plant, and Hamburg wanted them to treat the waste so it wouldn't pollute the river nearby. Vattenfall sued them for this. And then, in order to avoid the case, the Hamburg government said that they didn't have to do that anymore. So we see clear environmental risk here, and that there's a chilling effect on environmental regulation. I'm just going to give a quote from Tony Lando, a QC at Essex Chambers, who's participated in about 300 or so of these cases in counsel and arbiter. He said, "As a practitioner, I can tell you that there are states who are now seeking advice from council in advance of promulgating particular policies in order to know whether or not there is risk of an investor-state claim." So what we see there is a chilling effect on future environmental policy. So I'd say, knowing this risk, the burden of proof for including this mechanism is now on government. Why do you want it? The idea is that it will lead to more foreign direct investment. However, they have been around in trade agreements for a while, and they've studied it, and there's still no proof to show it's there, that this will happen. The UK government commissioned a report from LSE to look into the potential benefits that it would have to the UK and having this ISDS mechanism within, and it came back with saying that there would be no significant economic benefit, no significant political benefit, some economic risk, and some political risk. They now rarely refer to this report. It's buried away somewhere. But it's there. So the burden. So it's effective. The way we view this is it's another case of socialising risk while privatising return, and that element's really not needed. So I'm just going to close up before I get the 1 minute sign waved at me. The EU has notoriously, and in its regulation, adopted a precautionary approach to regulation, which is to say that if there is suspicion of risk, they have to prove that it's safe before we'll do it or allow it. The US have identified this as a trade barrier, obviously, which the EU have again said we will not back down on that. But there's actually a big struggle within the Commission itself right now. There's lots of people who don't like this. But our stance on this is we'd actually like, when it comes to TTIP, the European Commission to hold true to the precautionary principle. We can see lots of elements for risk, and to be honest, there's not much reward. So we're asking them to stop it and to scrap it now. You're now going to hear from British American Business, who will tell you that everything I've said is nonsense. However, just as my parting blow, I'd say that we were both actually, and British American Business, giving evidence to the Environmental Audit Committee, and if you read their report, you will see that they did come down more or less in our favour.
Thanks, Sam, for getting the first session off to an excellent start. Yes, growth, jobs, prosperity, all good things. Protectionism, hardly something we can defend for its own sake. But at what cost? Where do the public interests lie here? Is it a dumbing down, a dilution of environmental protection, food safety legislation, which is simply seen as a crude barrier to trade or not? Those are the concerns. Now, I suspect we're going to hear a diametrically opposite presentation next. So in the interests of balance, we have an excellent spokesman. Emanuel Adam is Policy and Public Affairs Manager at British American Business, based in London. More than 500 member companies in London and New York, and is extremely well placed to give us the perspective of business and perhaps reassure us that some of the things that Sam's been saying are not such big concerns as he might have thought. We look forward to hearing your presentation.
So no one may think I'm clearly on the spot. This is not that surprising to me, at least not least since I had my grandmother asking me about ISDS over the Christmas dinner last year. And I look forward to discussing some of the points that Sam raised. I was asked to give a business presentation, and I will stick to that because I think it will allow us to have a good discussion afterwards. And I will also try to keep my remarks a little bit shorter to allow a little bit more time for questions. And I would like to start with a story about a lady called Penny. Lady is a textile designer I met in Bristol last year. And she creates fabrics and wallpaper, and she designs lampshades and other interior items. And she basically prints her own paintings on these items. And she's been in corporate life for most of her life, and then decided to turn her hobby, textile design, into a profession, creating a company. After a few years already, most of her, or at least a big chunk of her production goes outside of the UK. And it was a lucky coincidence, her daughter studied in New York, that she explored the US as an important market for her products. Getting her products to the US, however, was very difficult. And now I talk about some of the things that Sam already mentioned. She had certain custom barriers, and she had, and now it comes to regulation, to test her fabrics twice for fire, inflammability. Once in the EU and once in the US. Well, this was not necessarily a reason right now for her to give up her exports to the US, but it created costs for her, and it was an administrative burden, and it clearly made things a little bit more difficult for her. So what am I going to do now? I will use 5 to 10 minutes now to use that case as a way to talk about trade and TTIP, and trade and its link to regulation. And there are two things I would like to focus my remarks on. First is that it is absolutely true, making EU and US standards more compatible is at the heart of TTIP. And second, I would argue that TTIP is a new type agreement. It is vast, it is massive, it is the biggest agreement we've ever negotiated. This raises a lot of questions. I absolutely agree with that personally and professionally, but it may also be an opportunity for us. We live, whether we want to or not, in a globalizing world. And trade and investment are the key elements of this world. And I don't want to bore you too much with figures, but I think it's important to know that every minute the UK and the US trade goods and services worth £400,000. So, okay, well, this is a big number now. But these £400 also represent lots of people who work for companies exporting, or lots of people who work for American companies in the UK. So, and I stick to the UK and the US because they are the largest bloc and the largest trading relationship, but we also have relationships with many other countries that are similar. On the one hand, we benefit from it because we like to buy products, and we have lots of products we want to buy, and there are lots of things that we enjoy, whether this is our iPhone or Netflix or other things, and we don't really like any borders or barriers that make these products less accessible. On the other hand, we as an economy, the UK, we benefit from it. The European Commission says in their trade strategy, well, we have to think about something that in 15 years from now, 90% of world demand will be created outside of the EU. So we want to participate in this because in the end, we hope to benefit from it. Yes, jobs and growth, but maybe there's some truth to it. Especially when we think about now Penny again or other business people, because they experienced that. So they could sell their products here in the UK, but sometimes this is not enough. They have to sell it somewhere else, and they have to look into markets, other markets, government and we as a trade organization, we support that. We want companies to trade and invest more because we believe it is good for our companies and it is good for the economies they trade with and invest in. Now, the other thing that Penny's case highlighted was her difficulties to get her products to the US. So, and Sam has already mentioned it, there are lots of things that we want to see addressed by TTIP. Tariffs, and I mean, just as a side anecdote, yes, there are a few things that are a little bit funny, that over time tariffs have developed in a different way, and sometimes we pay a lot more tariff on the product exported from the US to the EU, and if we were to export the same product back, we would pay higher tax or a lower tax. So there are a few things, and that's what we want to get rid of. That's fine. But the invitation said that there's a big interest, and TTIP has it as its core interest on standards and regulation, and this is why I will focus on that. In the UK, in the EU, US, wherever you go, most of the countries at least, we have regulatory systems in place. These systems have grown over time, and regulations are laws that protect our health, our environment, and they guarantee safety for consumers and citizens. We know that these regulations are usually the result of very long deliberations and are often based, and I absolutely agree with that, on domestic considerations. This is fine, as I said, and absolutely understandable, but in some cases it is also tricky. And it's tricky, especially when in some cases regulations are different, but they have the same goal or objective. In some cases we don't, okay, but in some cases we also have. So this means that companies, Penny for example, again, they have to either test certain things twice or they have to manufacture in different ways to comply with EU and US law. So now when I argue for something, I would say that if we look at, and the invitation said this also, at the increase of trade and investment over the past, I'd say 50 years, it's incredible. And then we look at the development of standards and regulations. I have to be careful here, but I would argue that the development and the alignment of standards and regulations has not caught up with the development of trade and investment. So there's a mismatch, and we have to ask ourselves, okay, what is it what we can do? I happened to find an interesting report, and I know that this example is usually always brought up from the automotive industry, but unfortunately there's also where we can find the best information. But I dug a little bit deeper, and I found a report from the Congressional Research Service that explained the development of vehicle safety standards in the US from 1905 over to the 1960s. And it was quite interesting to see how in the beginning all the different states had different standards and regulations in place. And then just slowly, step by step, they found out, okay, well, this doesn't really make sense because you drive your car from one state to the other. And they tried to push for national legislation. It was difficult in the beginning, so government would introduce legislation that only required certain harmonized safety standards for government. And then at some point, a senator would say, well, this doesn't really make sense if the politician drives in a car that we basically certify, but the consumer on the street could buy a car that is not. So more and more they came to the conclusion, okay, well, let's find an agreement here, let's learn from each other, and let's introduce national legislation on the topic. So I would like to take this now to a next level. So if we now think, okay, well, the Americans had lots more and more cars, so this created a new situation, so they had to respond to it. Now we have more and more trade and investment, so we want to respond to it. And TTIP wants to do this, but TTIP is not necessarily new. I haven't been that long involved in that world, at least a few years now. But discussions about how we can get the two regulatory systems together have been going on for a long time, at least since the late 90s, where they created things like the Transatlantic Economic Forum and then later the Transatlantic Economic Council, lots of subgroups that tried to get the regulators together to to somehow develop at least standards that are equivalent or similar, so that we don't continue creating trade barriers that are difficult to manage for companies. TTIP is now, and now I come to the point from the beginning, the opportunity to get to this point and make EU and US regulation more compatible. And I think from a business view, or from a pro-trade stakeholders view, people were quite lucky and excited that governments even took this step to launch negotiations, because this was not clear at all, because they knew it's going to be so difficult, because there are so many agencies involved and it's very technical, and yes, you need to get two different cultures somehow together, but they did it, and this is why we have to use that opportunity. For business, this is a chance to increase trade and investment, and it will hopefully decrease cost for us. For the larger ones that we have in our chemical or pharmaceutical sector, of course, anything that will make trade easier will benefit, because we have a lot of trade going back and forth. It may also help Penny with her small business, because she has even more difficulties managing these differences between the two markets. There's one thing, however, where we absolutely agree. That is that we do not want TTIP to challenge the regulatory autonomy that the EU and the US have. What we think is that TTIP will allow for us to find ways to look at our different systems and agree where we provide the same level of protection and make these things more equivalent. In addition to the direct benefits, let's say, if we are lucky at some point, things may be cheaper a little bit. In addition to these direct benefits and very concrete benefits, for example, allowing Penny to trade more easily, there's a second dimension to it, which to some of our members may be even more important. The European and American systems, regulatory systems, are the highest and most sophisticated in the world. And yes, I know that there are big differences between the Americans and us Europeans. But at the same time, if you really think about it, we are also quite similar. I don't really expect people over there, in some cases, I may have personal reservations, but overall, I think I don't feel unsafe in the US. Not less than I do here. So I think we are quite similar in that sense. So both sides provide a regulatory system that is considered to be quite sophisticated and quite high level. So if we now try to get these two sides together, we may be even more powerful by shaping a regulatory system that goes beyond the EU and the US. There's a second element to it. There are international organizations that already try to do this. But we also know that it's difficult, even more difficult in the multilateral level, to get to an agreement. If the EU and the US get closer, we have a powerful voice, and we can really shape and push for this even further. So I don't want to come to a conclusion without mentioning environment at all. And I would like to build the bridge between what I've just said and environment. If we know that TTIP is a powerful agreement, can be a powerful agreement, we should also have this in mind when we think about its impact on the environment. Questions in regards to the environment. When I prepared for this session, and when I noticed that the TTIP debate would advance and would more and more address environmental issues, I looked up a little bit things myself, and I was quite surprised to see that for the WTO, the protection and preservation of the environment is already one of the key principles that they have. And when you then look on the European Commission website, they also say that the protection of the environment is something that they want to have a close link with trade policy. This is why TTIP will have a sustainability chapter in it, trade and sustainability, where, I mean, we have not to forget that TTIP is a trade agreement, but there will be a sustainability chapter where certain commitments could be made. And the European Commission is pushing for very strong commitments. We as a business community, we support that. And again, I also see this might be a chance using TTIP as a vehicle to push for certain things. Let me conclude. I said in my remarks that we as a business community understand TTIP as a way to increase the ability for companies to export and to invest. I think that trade and investment needs a regulatory response. TTIP could give this response by making EU and US regulation more compatible. So again, coming back to Penny one last time, if the EU and the US were to agree that it is either enough to test her fabrics once, either in the EU and the US, and it would be recognized by the other party, this would be one way, or, and this goes even more into the technical details, they agree on a standardized procedure of testing. If the outcome is different, okay, but maybe at least will make things for her easier if there is one system, one formula, one document in place that she has to fill out. We have never negotiated an agreement like this before. It is a new type of an agreement, and it will be a reference point for trade and for environment. I look forward to your questions later. Thank you.
Thank you very much. Thanks tremendously, Emanuel. You see, it's never as clear as it first appeared. We started off with something which we thought might be a problem or a threat for the environment, other kinds of regulations. We listened to the second speaker. Actually, what we have here is an opportunity. I mean, couldn't even the most green-minded of us feel a certain sympathy for Penny, this lady confronted with two different sets of tests for fire safety in order to market her product? Yes, and if environmental concerns, as it's often said, do not respect national boundaries, why should there be differences between the United States and the European Union in these matters? Some really good questions, I think, raised by that polarisation between the first two speakers. And of course, this stage we bring in a lawyer who will be able to point out clearly the way forward on the basis of past experiences of resolving free trade and environmental matters. We're lucky to have here Alan Bates, a barrister who specialises in EU competition and public law, who's written widely on issues including state aids, and also a trustee of the Lawyers for Animals Welfare. I notice they've got a stall out in the foyer. Yeah. Thank you very much, Alan.
A very good morning to all of you. And thank you very much for that introduction. And as a lawyer, I mean, that's the primary perspective through which I'm dealing with those issues. So my slightly geeky presentation is going to be focused on the rules, because of course at the moment we don't know precisely what the rules are going to be. And as lawyers, we don't often get involved or too involved in things at the drafting stage, but it's once the rules are there, it's the interpretation of the rules and how to make fairly broadly worded provisions actually mean something in practice, which we tend to find interesting. But I also have other perspectives on this issue as well. Being involved in the Association of Lawyers for Animal Welfare, I advise a lot of animal welfare groups, including Compassion in World Farming, who've been very concerned about the TTIP issue, although I wouldn't necessarily share the same perspective as them in all aspects of the TTIP debate. And also, my wife runs a manufacturing company where she makes candles, and she's recently been grappling with some of these issues of how to comply with EU regulations as well as US and other countries' regulations for making and labelling and importing her products. I've got that perspective as well. What I don't pretend to be is a TTIP expert, and frankly nobody is at the moment, because although there's a lot of noise around TTIP, the actual important substantive content of it is of course substantially still up for grabs. I think it's important to lay my cards on the table in terms of my view of trade, because I think that's something that underlies anyone's approach to these issues. I think by and large free trade is a good thing. I think by and large the WTO has been a good thing. As a pro-international development person who's got a background coming from a developing country, I'd say in many ways the WTO regime doesn't go far enough. Of course, I'm also concerned about the environment and animal welfare. So for me, the question is really how can we do a trade deal, which to my mind is obviously a useful thing to do, in a way that reduces unnecessary barriers while also ensuring that the substantive standards for environmental, human health and animal welfare don't fall. Now, I do have a concern about the amount of scaremongering that there is around TTIP, because I think it's fair to say that there is quite a lot. Especially in the UK, there's been a lot of comments about threats to the National Health Service and privatisation of the National Health Service originating from TTIP, for which there is absolutely no evidence whatsoever as far as I can see. And if any of you want an example of how not to do lobbying, you can go onto YouTube and watch the evidence given by I think it's the chief executive of 38 Degrees to the Biz Select Committee for just an example of an excruciating evidence session with someone giving evidence about a campaign opposing something about which he apparently knew nothing. So to me, the issue is really not about being anti-TTIP, but thinking about how the drafting can be tweaked. And I do have a concern that by in relation to Friends of the Earth, with great respect to Friends of the Earth, but by adopting a position that's anti-TTIP, whether that means we're missing an opportunity to do the important work of influencing the substantive drafting of some of these important clauses. Another thing that informs my approach to these issues is just a sense that there isn't a lot here that's new, because you read a lot of campaign literature opposing TTIP, and it makes various points about sovereignty and about the exceptions that apply under the GATT, which will be General Agreement on Tariffs and Trade under the WTO regime, that are being imported across to this regime. And just as someone who practices EU law and a little bit of WTO law, just seems to me there isn't actually a huge amount that's new here, and it's important to perhaps not get too excited about things that aren't actually very substantively different from what is already there. So what I propose to do is just deal with 5 important questions which I think we need to ask ourselves in order to understand the risks and rewards of TTIP, and then come up with some ideas of my own really about where the real risk areas lie and how they can be addressed. So I think the first question is, what's the background to TTIP? What's already out there? Now, there are already a huge number of what are called BITs, which are bilateral trade treaties. There's already the WTO regime, there's already EU law, so there's already a lot of things that circumscribe what national governments can do and what even the EU can do in relation to regulation. And things like the ISDS mechanisms, dispute resolution mechanisms, they already exist under the WTO regime, and the possibility of companies bringing proceedings directly against states is something that's common to a large number of BITs, and indeed there have been cases brought against the UK government under bilateral treaties. The next question is, well, how is TTIP different from what is already out there? Well, I think TTIP is really, in many ways, similar to any other BIT. I think what makes TTIP slightly different is just the context in which it's being negotiated, which is that tariff barriers between the US and EU are already very low. I think it's about 3% on average tariffs. So since there isn't a lot of benefit to be gained by reducing tariff barriers, because there really isn't very much there, there's a greater focus on non-tariff barriers and how they can be reduced. Now, most bilateral trade treaties already include provision for dealing with non-tariff barriers. So it's not as though this is something new, but it's just that in terms of where the focus is going to be, what the change is going to be, obviously where tariff barriers are already low, non-tariff barriers are going to be more of a centre of focus. the dispute resolution mechanism being a little bit more like a BIT-style mechanism, so one where you have companies being able to bring proceedings rather than only governments being able to bring proceedings, is different from the WTO regime, though not, as I mentioned, different from many other BITs. The difference, I suppose, with the EU regime is that you don't have the European Court of Justice with its very pro-integrationist stance interpreting TTIP. So, of course, when you've got generally worded provisions in EU treaties, the European Court of Justice tends to give them an integrationist interpretation. So you've got a very activist court interpreting it. It remains to be seen whether or not a similarly activist approach would be taken by panels dealing with trade disputes. I think the answer is probably no, based on recent experience. I mean, again, just showing that there's nothing new under the sun. I did my master's dissertation, I think about 12 years ago, on animal welfare in the WTO, and at that time there was a huge amount of concern about how the WTO was going to undermine animal welfare protection, and there was a lot of justification for that concern at that time. Of course, last year we then had the decision from the WTO in the seal products case, where they've used the morality exception in quite a generous way to the states in order to allow animal welfare to be protected. So I think you do see these shifts over time in the way that dispute resolution mechanisms take account of external pressure and public concern about animal welfare, labour standards, etc., which sometimes give rise to doubt as to how they can be fitted in within the exceptions for public security, public health and the environment that exist in the GATT and other trade treaties. The fourth question is whether or not the WTO is a more or less democratic mechanism. Now, it seems to me that if you have EU, which, although not a perfect democratic institution, has a lot of democratic input into it, perhaps a bilateral mechanism is more likely to reflect public concerns than a multilateral mechanism like the WTO, where it may be more difficult for the EU to influence how disputes are dealt with and how issues that arise are dealt with. And when you've got two main players, the EU and the US, actually negotiating with one another about how some of the tricky issues can be dealt with. Fourth question, are US standards actually lower? Well, it seems to me that they are in some areas, but not in other areas. So it's important to make distinctions between those different areas. I think in relation to chemicals, the European regime under REACH is a lot stricter. On the other hand, in relation to pharmaceuticals, I think it's generally agreed that the FDA regime in the US is stricter. So, it's not true that the US regulation is generally lax. I think there are particular issues in the agriculture sector to do with, for example, chlorine treatment of meats, etc. I think the UK is going to have to move in the direction of some sort of treatment of meat anyway because of the extent of E. coli that's being found in chicken. So they'll have to find some sort of solution to that anyway, although there are alternatives to chlorine treatment for doing that. But provided that that TTIP is drafted in such a way that the substantive standards that have been decided on by the EU are able to be protected, which is what the European Commission says that it will achieve in the negotiation, I don't see that there's on that basis some reason for objecting to TTIP in principle. So it does come down then to the drafting and whether the drafting's tight enough to enable the EU to maintain the standard it wants to maintain in relation to that issue. And then the fifth question is dispute resolution mechanisms. The question being, if not ISDS, then what? Because as lawyers, we believe in the rule of law. There has to be some mechanism by which trade treaties and other sources of law can be enforced. Under the WTO mechanism, there's an interstate dispute resolution system, which has proved cumbersome. It's probably been more advantageous to the large business players who are able to influence national governments to actually take up their cases through the WTO mechanism, and perhaps smaller industries or smaller companies are actually less able to utilize the WTO dispute resolution mechanisms because of the need to lobby the state to take on your case. So it seems to me that in general it's pro-rule of law that there should be some sort of dispute resolution mechanism. The question then is, what should that dispute resolution mechanism be? Should it be through national courts? And if so, in the case of the EU, where would that dispute resolution take place? Is it fair to expect foreign companies to litigate issues under an international treaty in the courts of one of the parties to the treaty? So in other words, that party to the treaty is almost a judge in its own cause in terms of whether or not it is complying with the obligations under the treaty. Perhaps that is something that's acceptable in this case, given that we're talking about EU and US justice systems that can generally, judges can generally be trusted to rule against their own governments. But you can see why the ISDS mechanism has been developed in relation to BITs generally, because of course in many countries that is not the case. And also the idea of having international dispute resolution mechanisms that can interpret their own source of law, their own treaties, isn't something that's new. After all, you've got the European Convention on Human Rights. You have exactly the same issue of national legal systems and a multinational legal system running along in parallel. So again, this is something new there. Now, in terms of what the concerns are as I see it, so I'm running out of time, so I'll be as quick as I can. But there isn't really enough time to engage on all the different aspects of TTIP, but just to highlight a few. The most favoured nation clause, I think it's important to ensure that that's limited to so that it doesn't include other bilateral investment treaties. So, for example, it's not possible for a company to come along and say, well, because the EU's got a more favourable regime that it's agreed with a particular other state, therefore we're able to benefit from that. So I think there's scope for limiting the most favoured nation clause there. In relation to the national treatment rule, which is that you have to treat, say, US producers in the same way that you treat national producers in relation to things like inspections. I think there needs to be enough flexibility there to enable the EU to inspect imported products to ensure that standards are being maintained, where there's a genuine suspicion that the US inspection regime may not be equivalent. In relation to the exceptions for public security, public health, morality, etc., I think there's real issues about who is going to decide on the proportionality of those measures, and also how animal welfare and labour standards, which are things that don't easily fit in under the category of environment, but normally have to be brought in under the morality category, how that's going to work out. And I think there's room for putting some specific language into TTIP to deal with that. Another area of concern is the rule on fair and equitable treatment, which is obviously a very broad concept unless it's narrowed down. And the European Commission has said that it wants to narrow it down by reference to specific examples. So there would only be a breach of the fair and equitable treatment rule if there was some fundamental unfairness, for example, in the way that a national court system had treated an American company. And I think provided that's done, the risk of the fair and equitable treatment rule being given a very broad interpretation so that it can cover things that it was never originally intended to cover, I think can be very substantially reduced. A similar issue arises in relation to the prohibition on expropriation. I remember a few years ago when the Labour government then wanted to ban fur farming, there was an issue about whether they could do that without compensating all the fur farms, because otherwise there'd be an expropriation. Expropriation, of course, already being prohibited by Article 1 of the first protocol of ECHR. So again, that illustrates how these issues about potential chilling effects, issues around what is and isn't expropriation are ones that the UK government's already having to grapple with. And I have to say, in response to the one of the things expressed by our speaker from Friends of the Earth earlier about Toby Landau QC's comment about governments seeking legal advice before they do something to ensure that it's lawful, that seems to me as a lawyer to be quite a good idea. I think that big areas that need to be looked at, obviously the right to regulate, the ability to carry out inspections, and also to make sure that there's genuine equality between the substantive EU standards and the substantive US standards. So again, it's going to be about specific language around that. And then the other big area, I think, in terms of dispute resolution mechanisms, there's questions about remedies, the extent of the monetary damages that, say, the EU might have to pay to a particular company which claims to have lost money as a result of an unlawful regulation. And of course, in the EU, national governments already have to pay damages, but that's subject to the Frankovich principle, those of you who studied EU law, where there has to be a sufficiently serious breach. So there's a threshold test of seriousness that has to be satisfied in terms of the fault of the member state before it incurs a liability to damages. So I think that's a specific area that can be looked at. And also the transparency of the judicial process and the membership of the dispute resolution panels, because of course we know as lawyers that often the identity of the judges and where they're coming from can be very important in terms of how weight is given to different considerations like the environment, human rights, etc., when interpreting provisions that can be interpreted in more than one possible way. And it seems to me that having some sort of standing judicial mechanism, perhaps drawing on judges from the EU and judges from the US, regular judges, rather than partners from city law firms who are the more normal recruits to WTO dispute resolution panels. So I have to be careful because the QC in my chambers, who's chair of the WTO appellate body, so I wouldn't suggest that he is inadequate in any way. But I think just having some sort of standing court system that's transparent, where all the documents and submissions are available online, anyone can go and watch the court proceedings. I think that's also going to be an important safeguard for maintaining confidence in the in TTIP going forwards. Okay, thank you.
Thanks tremendously, Alan, for that presentation. Maybe it's served to convince some of you that the truth lies somewhere between the two extremes. We shouldn't be scaremongering in one way or another about this. The parties will come to the negotiating table with equal powers. The procedures will produce some result which is beneficial not just for trade but for the environment, and maybe pigs will fly. The questions are open to you. We've got a 10-minute session. You can challenge any of our speakers. There are, I believe, microphones if anybody is quiet. There's a lady here. Microphone here. Would you like to say who you are?
Hi, I'm Diana Powers from Paris, France, Earth Strategy. I have a question for Adam.
Emanuel, yes.
Emanuel, sorry. It made you, when you spoke, you made it seem as though there was some kind of open forum going on about deciding nice harmonized regulations, and yet in the very structure of the proceedings, for example, a dispute, it's the company who takes the government to court, right? And therefore, they're wanting a lowering of standards by definition. They're not asking for a raising of standards. So it's not really an open forum. It's a one-way, a one-sided system that always tends toward a lowering of standards by its very structure, right? So I was wondering about what you had to say about that. Let's see, what else?
That's surely a question in itself, isn't
Well, that's
it?
okay.
We'll pause that.
May I just ask, are you talking about the ISDS proceedings?
Right.
I don't know whether I would say that the objective of a company who takes a country to court is to lower standards. ISDS proceedings, and please correct me if I'm wrong, they have already quite a specific number of things that need to be met in order to actually have them. So discrimination, unfair treatment, expropriation. So, and companies can ask for a reimbursement of profits that are lost through a certain regulation. I don't think that you could go into these proceedings with the objective to lower a certain standard.
I think you can go into a proceedings with whatever expectation you want. I mean, people do things for different reasons. So some people might just be, one company might just be going to try and recover costs. Another might be trying to make the case so expensive that it puts the government off going through that regulation, or pursuing something similar in future to actually be punitive, to punish them for doing it and make them think twice in future. I think it's very hard to say why people do things, but you can certainly see a range of reasons.
Alan, did you have a view?
Yes, I think important to bear in mind that just because people bring cases doesn't mean they're good cases. And we've had a similar situation with the challenges to the tobacco labelling bans within the UK, where proceedings have been brought in Scotland, in England, at the EU level, etc., by the tobacco industry, who have failed to win, any of these cases. And I think when you've got, big players like the US and the EU, I don't think they'll be too easily intimidated by the cost of litigation. I have to say, the UK government often instructs me to argue cases where we've got very little prospect of winning, but they never seem to be put off from having a go sometimes. So I think we have to sort of be realistic about this. The other thing I would say is that there is a little bit of a myth here that the only way that TTIP is going to be enforceable judicially is through the ISDS mechanism. In fact, you've got the national courts and the EU court running in parallel with the ISDS system. I read an article in The Ecologist a couple of months ago which suggested that this was all an unfair regime because only companies could bring proceedings in the ISDS and environmental groups, etc., wouldn't be able to bring proceedings at all. Well, obviously that's not true, because they could bring proceedings in, for example, the English courts and have a preliminary reference question referred to the European Court of Justice. So I think that's why it's important to look at the mechanisms and see how companies and other organisations could challenge, and also what the scope of the right to challenge is. Is it only where you're challenging the way in which a particular point of detail has been applied, or can you also challenge the outcome of substantive discussions and negotiations where a compromise has been reached through the technical committees that are going to operate between the EU and the US?
I'm trying to get in as many questions as I can. There's a gentleman in the middle there. I'd like to say who you are.
Nicholas Sadler from St. Louis University, Brussels. I would like to make two remarks regarding TTIP. I try to be as pedagogic as possible, given that kind of difficult legal issues. Firstly, with respect to the ISDS, I'm afraid that there is a fly in the ointment, given that at least with respect to challenging EU legal acts, the Court of Justice of the European Union has constantly ascertained its monopoly upon adjudicating. So let's imagine that a company challenged an obstacle regarding its investments within the EU with respect to an EU legal act, and is claiming damage according to the EU treaties. Such a case has to be adjudicated exclusively, firstly by the General Court, secondly by the Court of Justice of the European Union. So the question is how to square the circle, because such a mechanism is going to call into question the monopoly of the Court of Justice. So the Court of Justice has been reaffirming its monopoly in its opinion on the accession of the EU on the Human Rights Convention. Second remark, Mr. Samuel Lowe stressed a key element in two chapters that's where the position of the European Commission has been published just a month ago. It's SPS and the TBT chapters enshrining a clause of mutual recognition. Mutual recognition made sense in 1981 when the Court of Justice of the European Union affirmed that principle, or proclaimed that principle, in the Cassis de Dijon case. It made sense at that time on the grounds that the EU harmonization process was faltering indeed. And so the principle of mutual recognition prompted a very ambitious program supported by Jacques Delors Commission that led to the establishment of the internal market that's reckoning upon thousands of regulation decisions and directives. So the idea now is to usher a new approach with respect to mutual recognition, but to place it in a broader spectrum, applying both to US jurisdictions as well as to EU jurisdiction. But we are missing a key element, is that the TTIP as far as it is advanced nowadays, does not set out any harmonization systems. So perhaps I come back to that issue in my forthcoming speech. My view is that mutual recognition goes hand in hand with harmonization. And so one piece is missing so far.
I'm very grateful for those comments, Professor Steer. I don't know whether there were specific responses you wanted to give to them or whether they're self-standing observations. I'm trying to get in as many questions as I can.
Can I just come back briefly on your first point about the European Court of Justice and its position? I think that it's not uncommon for there to be parallel systems of law, and while it's true that the European Court of Justice would have a monopoly on deciding whether or not a particular bit of EU legislation was valid or invalid, actually that the ISDS is not invalidating, wouldn't be purporting to invalidate any bit of EU legislation. All it could do is say this legislation is unlawful and therefore we're going to award monetary damages, but it wouldn't in itself stop the effectiveness of the legislation. So it's really quite similar to where you have a judgment from the European Court of Human Rights, for example, saying it's unlawful that in the UK prisoners don't have the vote. Well, prisoners still don't have the vote because our courts in England and Wales have taken a different view.
Yeah, I agree with that, but it's about extra-contractual liability.
Is there time to fit in one last question? Anybody wishes to raise it? Yes, you have the microphone. We'd like to say who you are, where you're from.
Yes, I'm Ivana Dimitrova, and I did European Studies at the University of Hamburg. And I think Mr. Lowe mentioned the example of Vattenfall, and then I thought of the Germany nuclear power phase-out. And as far as I'm aware, Vattenfall and other energy companies are thinking of suing the German government for the nuclear phase-out. So my question, the first question goes to Mr. Bates. And legally, do you think that Vattenfall and the other energy companies are actually stand a chance of winning a potential court case? And to the other two speakers, do you think that ISDS could act as a deterrent for governments to adopt more ambitious environmental policies? Thank you.
Okay, I mean, I don't know what the prospects of success are in that case. Obviously, it's not a case under TTIP, and the question will be what assurances did the German government give to that company that its nuclear program would be maintained? So it's really a legitimate expectation type of case. I mean, I think this links into what I was saying about expropriation, that there could be an issue under TTIP as to whether or not a massive change of government policy that renders existing investments valueless is a form of expropriation. I think that's an issue that needs to be dealt with expressly in the drafting.
So the Vattenfall case, you didn't ask me if I think it'll be successful. I'm not sure. I don't know. But in terms of, do I think that it can lead to governments thinking twice about future regulation, and even in the minutiae of how actually regulation is applied, because there's a big difference between you can create a regulation, but then actually the implementation of said regulation is actually up for grabs a lot of the time. Yes, I do, and I think you can see a lot of. I mean, so a recent case I can bring an example of. So I think it was last week or the week before, Canada again got sued under NAFTA under an ISDS clause, and it was because they wanted to a company wanted to expand their mining operation into a zone that had environmental protection. I think they breed whales there. It's a whale breeding ground or something, and the government, Canada lost, and they were forced to pay money. But there's a dissenting view amongst the arbitrators, and they're actually in one of the more transparent panels. And he said that he's very worried that from now on this will make the Canadian government think twice about pursuing such measures. I mean, it's very clear to see how. And also, there's been a lot of talk about ISDS. Oh, it's there already. But I mean, why is it there already? You've got the examples from the past with developing world governments and why it might be necessary there. But in terms of the EU and US, is it? I mean, there's lots of other routes companies can take. For one, they can get insurance. They could buy insurance. They could have within the contracts themselves actual provisions to deal with it under contract dispute within the contract. So So why is ISDS needed? It's not presumed to bring any economic benefit, any extra foreign direct investment. It just seems like another subsidy, as far as I'm concerned, or at least potential subsidy to government that mitigates risk for companies and puts it onto the electorate, because we pay and they are very expensive cases. So I have a lot of issues with it, actually, and I do think that it makes governments think twice. Maybe not the UK government, but also they can sue provinces. Hamburg was sued. If at the moment with fracking in the UK, it's actually the decisions on local government whether they want to ban it or not. Will a local government be so keen to take on one of these cases, knowing the cost? I would say that there is cause to think twice there, even if the national government itself might be bullish.
Final word, Emanuel.
I would say that we certainly have to learn a lot more about specific ISDS cases, as Alan said. We need to know what certain contracts actually say that are brought to an ISDS case. But again, ISDS case can only be brought if there was a breach or if there was a discrimination. And this ISDS is an additional tool, but it is not that much different from, let's say, a tobacco company going to a local court in the UK and basically asking them to have a process over plain packaging.
It's completely different.
This is the worst part of being the chairman, calling a halt to a discussion which is going splendidly, but I'm conscious that we need to keep on top of this schedule. So I would like to thank the three presenters for getting today's conference off to an excellent start. Thank you very much.
Thank you.